Hey everyone, James Willis from Daly Black here. Today we're going to talk about tricks and pitfalls that insurance companies run into when they try to meet their burden of proof to establish an exclusion under the policy. Now remember, the last time we talked, the issue I brought up was that it is the insurance company's job to prove that loss or damage to property is excluded under a policy. It's always their burden of proof, and it's never the burden of the public adjuster, the contractor, or the homeowner or the insured. So, one sneaky thing that many insurance companies do when they apply these exclusions and try to meet this burden of proof is that they go outside the four corners of the policy. The reason this is so important is that the only definition or exclusion that's going to matter later on in a court of law in front of the jury is the one that's actually within these four corners. But imagine this situation. An insurance company comes out to adjust a claim. They might fully recognize that the damage to somebody's roof is there. They'll say that was caused by a hailstone on the date of loss. However, we brought in our bigwig engineer, and he has essentially said that this is wear and tear, this is a manufacturing defect, this is vandalism, this is cosmetic damage, this is tree rub. Anything within their vocabulary that they know they can use to exclude the damage. That's always their burden. But when applying this burden, they sometimes go outside the four corners of the policy. They'll apply a definition for cosmetic damage that is not within the four corners. In other words, it's not the definition that the insured purchased when they paid their premium for the policy. So that engineer might be using a definition from the internet or an engineering handbook. He might even use the DECRA definition of cosmetic or functional damage on a roof for a cosmetic issue with the DECRA roof. And that might be okay, except that the only definition that matters under Texas law or any state in the union is the definition that's within these four corners. Because that's what the insured paid for, and that's what the insurance company owes for, and that's the burden of proof that they have to stick to. Back in 2019, Daly Black and myself tried a case down in Bexar County District Court. Now the issue in that case was that a softball-sized hailstone that the insured had photographed and measured with a ruler had come down and damaged a metal roof. The insurance company did exactly what I just described. They sent out an engineer who's pretty well known in the industry, and he said, that's all cosmetic damage. Nobody has to pay anything. Insurance company, you have met your burden at trial. Now what the judge ultimately ruled was that engineer, no matter how qualified he is not allowed to testify later at trial because his application of the definition outside the four corners of the policy would not help the jury. Another court in the Northern District of Texas, a federal court, recently recognized this exact same situation. In that case, I moved to strike the insurance company's expert. And what he ultimately had said was that the damage was cosmetic and it was not functional and it was not covered, and the insurance company had met their burden, except that once again he had applied a definition that was not within the four corners of the policy. And there the court said that the insurance company has failed to meet its burden to show that the expert's testimony is relevant because it is based on a definition of cosmetic damage that differs from the insurance policy's definition. Yet again, in the Western District of Texas recently, another court recognized that where an expert had applied the definition of the word damage that was not within the four corners of the policy, the court recognized that that wouldn't be helpful to the jury either, and that's not what the insured had paid for. The court there said that it would be impossible for the court or a jury to determine whether the, quote, damage the expert is discussing in his analysis or conclusion is damage that is covered by the policy applicable in this case. So what can we learn from what these courts are telling us? It's this. Always look to the four corners of the document. That's what the insured paid for. When an insurance company comes out and tries to meet that burden and that exclusion, remember, hold them accountable, document it, put it in writing, ask them to change their opinion if they're applying a definition that is not within those four corners. If you'd ever like to know more about this, we'd love to educate you at Daly Black. Give us a call anytime.